and you saw some of the learning objectives in the start of the chapter. You like that little transition? They all kind of fade in. All right. So when I say assignment, you say, you guys ever played word association? Where like someone says something and the first word comes to mind.
Contract.
All right. That's the first word that pops in my mind, but I thought that was just me. Assignment.
When's it due?
Homework. When's it due, right? And actually, assignment is a little like that in the law. It's when you give something to someone else, like homework, I guess. And delegation, you guys ever heard of delegating? Yeah, so it's the same thing in contracts, giving a duty to someone else. We're going to talk about beneficiaries. That was the question that I asked of you at the start. And look at the different types of damages and election of remedies. So, in every contract, there are rights and duties. And so when I talk in terms of assignment, I'm going to talk about rights. When I talk about delegation, I'm going to talk about duties. In a contract to purchase a car for $10,000, what rights do you have? What's that? Sure. In a contract to purchase a car, you're the buyer. And someone else is going to have to get it to you. Your right in that contract is what? To get the car, yeah. And the right of the other party, the seller, is to what? Get the money. Now let's switch it around. In a contract to purchase a car, your duty is to pay, and their duty is to deliver the car. That's how easy it is. So whenever I talk about rights and assignments and talking about things you get. So how does this work? The diagram on the left is supposed to clear it all up for you. But basically the idea is that if you are going to get some money, some service, a good or something, before you get it, you could assign it to someone else to get. So let's say I am selling my car for $10,000 and I also owe someone else $10,000. What could I do? Give them that money, right? They come to me, they're looking for payment, and I say, I don't have it, but I can make sure you get paid because I have a right to receive $10,000 under this contract, and I'm going to assign it to you. Now, why don't they just say, oh, okay, if you say you'll give me $10,000, I trust you. Why would they rather have an assignment of rights under a contract? It's more than just my word. They can actually enforce rights under a contract if that doesn't come through. Sometimes, though, if I'm supposed to get something under a contract, I can't really give it to someone else because whoever's given it to me will not want to do it for the other person. They'll just want to do it for me.
Some people do that a lot with houses, like pending the sale of their house. They will buy something like that.
So what right is being assigned?
Like they will sell you their house pending.
So they would have a
Something else.
duty to perform that they would delegate to someone? Let's keep thinking about that example, and maybe we'll come up with someone else during the course of our time where we talk about third-party beneficiaries. Maybe it'll fit in there. But, for example, what if I'm supposed to paint your picture and you assign that right to have your picture painted to someone else? Well, maybe I don't want to paint someone else's picture. Maybe I just want to paint yours. So I don't want that right assigned to a third party. For the most part, assignment can happen, and we don't always have to let the other party know we've made the assignment. Delegation. So I have a duty under a contract. This comes up a lot with me during the summer. I'm not working, not teaching as much, want to make a little extra money, so I mow lawns. And before you laugh, thinking of me out there mowing lawns, I'm big. I got a big operation. I actually hire a bunch of college students, and they go around and do all the lawn mowing. Perhaps you've seen my crew. They have a bunch of trucks, flatbeds, 3 of these lawnmowers that, pivot on a dime. They roll off the trailer. They run over your dog, trees, whatever's in your yard, and they race around your yard and get back up and take off. So I don't mow all the lawns myself. I've got people who do it for me. There's some important rules about delegation of duty. Even though I delegate my duty to mow lawns to these college students, ultimately, who's responsible? Right. So I'm at work here, and I get a call. Hey, no one mowed my lawn today. Well, hey, those darn college students, you better get after them. No. Who are they going to go after? Me. All right. So the second bullet up there, the delegatee owes a duty to the original party of the contract. In that case, it would be the college student owes a duty to mow the lawn, but I, the last bullet, am still responsible for it. So with every class, we always introduce new terms. In this case, the person who assigns a right is the assignor. The person who receives that right is the assignee. The person who delegates is the delegator. And the person who is delegated the duty is called the delegatee. Now, just like assignments, not every duty is delegatable. You can't delegate it. For example, anybody in here getting married anytime soon? No? Usually in other classes people go, yeah. So who wants to pretend they're getting married? This is the fun participatory part of class. Wow.
I'm getting married.
Awesome.
I'm getting married.
You're like in the role. You didn't even say like I'm pretending. You're like I'm getting married. All right. So when?
June 13th.
June 13th. This summer.
Yeah.
Awesome. That's cool. So you want to invite everyone to your reception. And you want to impress everyone in the class. So you're going to have today's hottest group singing the hottest hit. What would that be?
Anybody?
See, that always happens because no one wants to admit that what their taste in music is. It's like, well, if I say so, everybody's going to think, well, that's
All right,
stupid.
we're going to have 50 Cent.
All right, I just want to correct you there because this is being recorded. It's 50 Cent, but okay. And because I get this request often, and singing what try to keep it clean, okay? Singing what song? It took me a while to figure out 50 Cent was one person. In the club. All right, so give me some clean words in the club. No, that's not them. Gonna give me some background music? All right, you guys, you got to know some of the words of these songs. What? Party like it's your birthday. Are those words? All right. What was that?
You're going to say the party like it's your birthday, and we don't give up because it's your birthday. We don't give up.
Oh, okay. Well, I'll bleep that part.
I did, yeah.
Okay. We don't give up because it's your birthday. Is that how it goes?
Well, that was pretty bad.
What?
Very good.
I mean, it wasn't even close. All right. So,
You have it? Yeah, actually,
I probably made my point, but if you want to find the song, that's fine. So, it comes to your wedding day, the reception's there, and the place is packed because 50 Cent's supposed to be there, right? And the curtains go back, and I walk out and I sing that. What do you think? How well is that going to go over? You'd feel a little robbed, wouldn't you? So some duties, like 50 Cent having a duty to sing at your wedding, can't be delegated to someone else because they're personal to you. And the fact that they're the ones singing it is what matters, right? Anyone else got any requests? No? You don't want to be subjected to that again?
Michael Jackson beat it.
I remember when I was younger, I used to be able to do the foot, like he had that foot twist thing going on, and I used to do that.
I don't remember how that goes. You showed it?
No. But I do welcome you to take the floor, and if you'd like to. I'd like to see you do that moon walk and sing Thriller. All right, have you heard of beneficiaries before? When do you hear of beneficiaries? Right, that's usually the most common type of beneficiary. Actually, it's an example that's in your chapter too, where life insurance policies are actually contracts. And it's between the insurance company and whoever is buying the life insurance, and there's someone who's going to benefit from it. So, the chapter talks about the difference between intended and incidental beneficiaries. How do you know that a life insurance beneficiary is an intended beneficiary? You pick them and you what? You write it down in the contract, right? So that's an example of a contract that puts in writing who the intended beneficiary is. But don't be mistaken. Not every intended beneficiary is listed in the contract. Sometimes they are, sometimes they're not. And you might ask, well, why would someone intend to benefit someone but never mention it in the contract? There are a number of reasons. For example, probably 6 or 7 years ago, the college hired me to start teaching here. And anybody have a guess who the intended beneficiaries were? Nice, thanks. Who else? Like the whole class is silent. Yeah. Apparently that's still up in the air. As to whether you guys are intended beneficiaries of that contract or not. Huh? I enter into contract to teach for the college. Right? Who would they be intending to benefit from that? Yes, you all. Right? So apparently you guys are arguing breach of contract. But the idea is that you are intended beneficiaries. Now, if you go back in time 6 or 7 years ago, how many of you were going here then? Okay, scratch that question. I don't really want to know that. But how many of you knew me then? No one, right? So even though I didn't know you and you are not listed in the contract, the college intends every year to benefit the students who are in my class. Now, the section on intended beneficiaries breaks it down into two kinds of intended beneficiaries. The life insurance example in your chapter is which kind, creditor or donee? Donee. Does that make any sense? I'm the donor. I got some money that I want to give to a donee. So, let's think about it. Before I die, can I change my beneficiary? Yes, I can. And how much does the beneficiary have to say about that? Right. So I could, for the most part, unless I contract for something, I could change the beneficiary at any time.
What if you were like mentally unstable at the time?
Yes, so then we get into the issues that we've talked about in previous classes. Are you saying that I appear to be that way, or? So are you saying at the time I entered into life insurance contract intended to benefit someone that maybe I didn't have the capacity? That could be a challenge.
Or if you're taking it away from someone after,
right.
And then you lose your...
That's pretty common in wills. In fact, this weekend I got a call from someone who said that their father had died, and all of a sudden this handwritten note surfaced, and people were questioning whether it was really his intent or whether he had issues where someone got him to sign something that he really didn't intend to sign. But different from wills, contracts, yes, it is possible that someone could all of a sudden get mad about something and change the beneficiary in a life insurance contract because they had some mental issues. However, even then, the beneficiary, while this person is still living, has no rights to challenge that, right? They can change it if they want to. Now, let's say I die. Other than not having class, probably that day, would the beneficiary benefit from that? Yes. Could they enforce the contract? Yes. Okay. So when do their rights vest in a life insurance contract? When the person actually dies. Because after I die, can I change the beneficiary? Nope. I can't change my mind. I can't change the beneficiary. And I'm dead, so I can't enforce rights under the contract. So it's left to whoever that beneficiary is. We're staying here no matter what. All right. Incidental beneficiaries. We're not leaving. Incidental beneficiaries are unintended beneficiaries. In other words, someone gets a benefit from a contract even though they're not a party, even though no one intended for them to benefit from it. For example, GRCC contracts to have a parking garage built. Who is it supposed to benefit? Students, staff, right? Who might get a benefit from that even though GRCC never intended for them to get a benefit out of it? Well, I think that's an intentional thing. Right? The parties to the contract get a benefit, I hope. What's that?
Local people who work here or work around the city.
Right. They could get some, perhaps it increases the value of their property. Perhaps their business goes up as a result of more parking. Let's say you guys, you come into class, you're thinking, oh boy, I really have a hard time staying awake in that class, so I'm going to stop at the coffee shop across the street from the parking garage, get a coffee before I come to class. So after the parking structure is built, this coffee business, its profits go up threefold, right? Does that mean it gets to enforce rights under the contract? No, it's just an accident. It just happens. If they quit getting increased revenues, they can't sue GRCC and say, we were a beneficiary, because they weren't intended to benefit in the first place. It's like, imagine the coffee shop owner going over there while they're building the ramp and saying, could you move the entrance around so it points this way? Or stop work or start work. Unintended beneficiaries don't have any right to enforce the contract. Only intended beneficiaries do. Creditor beneficiary is a little tougher. Little example on the board there from last time. I'm A. I go to bank B. I want to borrow money for a house, which I did. And when I'm talking to the bank, they said, well, your mental capacity has been questioned a little bit, but you appear to be creditworthy, so we'll do it. Except we have one concern. That is that your wife obviously works much harder than you do, but her income is different than yours. We have a concern if you die first, then she may not be able to pay the mortgage. So we're going to ask you to enter into contract for life insurance. With a life insurance company. And who's the proceeds going to go to? If I die, where is the benefit going to go? No. The bank, right? They don't want it to go to her. She might keep it. So I enter into a life insurance contract, beneficiary, bank, where I have this mortgage.
Do they do that? Is
Sometimes.
that a real life example?
Yeah. Yeah, think about it. Definitely if they don't do mortgage life, they do have to have insurance in place when you have a mortgage. Fire, casualty, flood in some situations. So they enter into an agreement, and they only enter into that agreement with the understanding that I maintain this other insurance that I have. In fact, sometimes they put in the contract that if I don't pay it, they will. And if I cancel the insurance, then they're going to go get it for me and tack it on. So, you still thinking about me singing?
Yeah.
No?
Inside joke.
Okay, you can't tell me because then it wouldn't be inside anymore.
That's right.
Oh, okay. So, like plotting my death over here. So, let's say I go, oh, okay, I'll pay that insurance. And then as soon as I walk out the door, I've got the mortgage, then I cancel the insurance. Then they, as creditors who are benefiting from that, can enforce rights under that. Make me keep the insurance in place, pay for it, or charge me for it with interest. What's the most common way of discharging a contract? I have to apologize. I didn't hear what you said. What'd you say? Well, that's what discharge is, right? Discharge is contract goes away. No, actually completing it. It's up there. This is the first bullet. Trick. Yeah, the first bullet says discharge is the full performance of all duties. That's the most common way of discharging contract, because we're going to talk a lot about breach and conditions and all this stuff, but actually, more often than not, people actually do what they're supposed to under a contract. So, performance is one way of discharging a contract. Another way is a condition in a contract. What page does it talk about conditions? So on, let's see. On page 282 at the top, there's a couple examples there. Read example 9.10 and 9.11. That's example 9.10 and 9.11. So starting with the first one, what is the condition? Nope. 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 What? What was that? There is no condition. In fact, it says an unconditional promise, doesn't it? So what kind of contract is this? Bilateral or unilateral? Flashback. Bi, did you say? Yes, it is bi. You get a haircut?
Yeah.
That's good. So, yeah, a promise to do what in exchange for a promise for what? Promise to pay in exchange for a painting, right? Not a promise to pay $10,000 if you paint me. It's be kind of weird. I don't really want to be painted, but so it's unconditional. As soon as either party doesn't do what they're supposed to, it's a breach of contract. What's the condition in the second one? Yep. And the appraisal has to be what? Right. It's a certain amount of money. And so a condition up there on the slide is a possible future event that may or may not occur. So If it appraises at a certain level, then the parties have a duty to perform. If it doesn't, contract is discharged. So that's actually a way of discharging a contract is when a condition does or doesn't occur. All that precedent, subsequent, and concurrent, don't worry about it. It just matters what the timing is of the condition. What I want you to understand is what a condition is and what it means if a contract has a condition in it. Right. Pop quiz. How many types of discharge have we talked about so far? Yes, what are they? Performance and condition. When we talk about performance, the issue sometimes comes up, well, what is performance? Perfect performance would be what? Right? All right, everyone look above the blue line in this room, all the way around. Especially right here. You can see it. Or over the door. What do you notice? Yeah, it wasn't all painted, was it? Is that perfect performance? No. What would be perfect performance? Every nook, cranny, spot is painted, right? Which is kind of difficult. So the courts have said, well, substantial performance is good enough. Would you say if you had contracted to have the part above the stripe painted that this is substantial? Yeah. It's questionable. If I personally asked to have it painted and this is what they did, I'd probably say, no, I don't think so. So substantial performance is good enough performance. It's not considered a breach. It's a minor breach that just needs to be fixed. Now, why do we care about that? Because if it's just a minor breach that has to be fixed, the other party still has to perform. So think about it. I asked to have my house painted, and I go in, and I find a little spot down the corner, and I'm like, that's not perfect performance. I'm not going to pay you. What do the courts say about that? It's substantial. It was a minor breach, so what is the cure? They have to paint, and you have to pay. What happens if it is substantial performance, you're the other party, and you decide not to pay? You breached the contract. So that's what breach means, when you fail to perform. So let's say you're having your house built and you go by and it's about a month till it's supposed to be finished. You look at your house, you're like, I don't think it's going to be finished. What should you do about that? Stop paying? What's going to happen if you stop paying and then it ends up in court? What? It's not going to get done, right? And you're going to argue, well, I didn't pay because it wasn't done, and they're going to argue we didn't finish because you wouldn't pay us. So we'll talk a little bit about what to do in that situation when you don't think it's going to be finished. But the one thing you don't want to do is if it's substantial performance, to just suspend your own performance.
So if you had that person contract to paint with you, we probably haven't gotten to this yet, but what about if you contract somebody to paint for you, but you tell them maybe like a day or two before they're supposed to start painting, no, I don't want you to do this anymore. Can they still sue you for that?
Well, depends on what kind of contract it is. I mean, think back to what we talked about, unilateral and bilateral contracts. And, even if it's, let's say it's a bilateral contract, and you contract with them to paint, and before they can come to paint, you say you don't want to be in the contract anymore. Yes, that's a breach. The question comes as to what's the real damages. Okay? Has the other party started to substantially perform or not? trying to think of a good example. Let's say you hire a roofer to come fix your roof. And there's lots of roofers around. And so they decide they won't do it. Perhaps you should just get another roofer instead of leaving your roof open to have water come in or whatever. Sometimes the performance is conditioned on someone's satisfaction. So I want you to paint this to my satisfaction. I have to be happy with the paint job. If that's the case, courts usually say that's reasonable. I mean, if I'm down there with a magnifying glass trying to find a little imperfection so I don't have to pay and consider a breach of contract, most courts would say reasonable satisfaction. So in the case of a material breach, which means it isn't substantial performance, then the other party, the innocent party, can suspend their own performance. So let's say I ask to have this room painted, and I come in and only 3 out of 4 walls are painted, and they go, give us the money. What can I say? No, I'm going to suspend my performance until you do what you promised to do. In fact, there's a case in there, Kim versus Park. What page is that on?
284.
It's on 284 and 285. Why don't you take a few minutes, most of you probably haven't read this case, and read through it because this will be on your practical exercise. All right, anticipatory repudiation. I just like that because it's fun to say, anticipatory repudiation. Anybody remember In Living Color? Anybody remember that show on TV? Damon Wayans was always behind the bars and he would do that skit where he'd use those words. I always picture him saying, the anticipatory repudiation of... Anyway, that's probably just my own thing I got going inside my head. But anticipatory means to anticipate or in the future see a potential repudiation. And what is a repudiation according to your textbook? Because so far I'm not much help. Okay, you anticipate there's a repudiation.
That one won't perform.
Right, and what is it called when one won't perform? Breach. So in lawyer terms, you know, we have to say you think there's going to be a breach. In fancy terms, anticipatory repudiation. In fact, I'm sure I've mentioned to you at least 100 times I'm getting ready to go to Disney World. And we wanted to stay at this one resort. The first time we went there, they tore it down, so we couldn't stay there. The second time we went there, they launched this webcam on the resort. And you could go there every day and check on the status of construction. And it was getting, you know, like a month out, and they had this webcam on the construction site. And I've got tickets, I've got, you know, a room, I got the whole thing. And I'm looking with my students at this webcam, and there's nothing there. You know, you'd see like a backhoe go by, some guy carrying a piece of lumber the other way, and you're like, okay, I anticipate this might be a situation where there's going to be a breach because I'm going to get down there and I'm not going to have what I paid for. So if you think the other party is going to breach the contract, what should you do? Remember, this is before the time that they have to perform. Yep, ask them. Hey, it kind of looks like you might breach the contract. Is that the case? So that's what we did. I mean, would it make a lot of sense for me to pack up the family, suitcase and all, and go there and stand on the lot, you know, as the construction workers are walking around? All right, which one's my room, you know? So ahead of time, I contacted them. I said, look, it looks like you're going to breach. It looks like you're not going to be able to do what you promised me to do and which I paid for you to do. And they said, yep, you got us. We're not ready. We'll put you up someplace nicer. So it did work out. But what would be my damages if I end up going someplace not knowing that? Right, getting down there, going there, having to make different arrangements to stay somewhere else, it could be fairly costly. So the first thing we want to do is ask if they're going to breach. Yeah.
Like say you bought, like just kind of like how you were talking about, you bought, you purchased a room or whatever, thinking and that the place was not under construction at all, and you know that you're going down there, and you get down there and half of it's under construction and half of it's not. So like, you know, half the pools are closed and like the bars and the restaurants and stuff. Yeah, you can still stay there. I mean, can you do anything about that?
Well, what's that sound like? When the other party performs, but they didn't perform. Yeah, so it becomes an issue as whether it's substantial performance or not. And if you're booked to go some nice place and they're like, sorry, the pool's drained dry, sorry, you're going to have to stay in a tent out back, you know, whatever it is, then you may end up in a dispute if they can't make it right over whether it was substantial or not. Okay? So, and that actually did happen to me one of the times I went to stay there. They did say, oh, well, we have some old, you know, nasty rooms over here on the side that we didn't knock down. You could stay there if you want, but it might be kind of noisy. I'm like, nah, I don't think so. So, yeah, those issues do come up. In fact, those come up. I mean, how often do they rip down a whole resort before you go to stay there? Not so often. But often there's situations where I booked a room and I stayed there because of a pool or some special attraction and it wasn't open while I was there. Right? Now, the reason this is important is because it depends on what the other party's response is. If they say, yep, you got us, we're going to breach, we're not going to be able to perform, then you can treat it like it's a breach ahead of time, which means you can go make other arrangements. Like say you order some stuff from a factory and you're driving by the factory and it's always dark and locked up. Wouldn't you want to, before you pay, find out what the heck's going on before you pay your money? Sure. So you definitely would want to find out before performance whether they're going to actually perform. Discharge by agreement. You guys are looking like you want a fun group activity. You're like, it's time to turn the class over to us. So that's what I'm going to do. So discharge by operation of law. There are a number of ways that a contract can be discharged. This is the last way, and that is the law steps in and takes the contract apart instead of agreement or some of the other ways that we talked about. So if one of the parties alters the contract without the other party's permission, then the law says then it's not the agreement that they had. So think about it. You go and you negotiate a contract at a car dealer and they write something on the contract because you agree to something differently. What do they usually have you do? Initial it or something to show that you agreed to those new terms. If not, it may look like they altered the contract without your permission. Statute of limitations. Statute of limitations is a statute that says after a certain period of time, you can't bring the lawsuit. So what if you get a call one day and someone says, hey, we're so-and-so credit company, you owe us $5,000. And you're like, I never heard of you. I don't know what you're talking about. They said, well, we used to be so-and-so that used to be so-and-so. Oh, now I remember. And, you know, you haven't been real good about paying. We haven't been real good about collecting. You owe us $5,000. Let's just pay us $2,000 now and let's we'll get rid of the contract. What does that sound like? It does sound a little like a scam, right? On that last slide where we drew out the examples, which one does that sound like? Will you take 2 instead of 5? Right, the accord and satisfaction, right? But be careful, it could be a scam. Perhaps the time has run up for them to even sue you under the contract because of the statute of limitations, and they're trying to get something out of you versus nothing. Right? That has happened before.
I got a phone call like that.
Did you really?
Yeah,
I've-
the same exact thing. They were asking for my dad because I answered the house phone. They were asking for my dad, and I was like, well, he's not available. And they were like, well, is this spouse? And I was like, yes, yeah. And
You're married to your father? What? I'm sorry, I was confused there for a second.
No, I was just like, she's like, well, I noticed that his credit card is $45 late on the payment. and my dad always pays, like, right away, pays off his stuff just to keep good credit. And she's going on and on. She's like, well, you owe us $45 for this, and he's kind of late. And I was like, wait, how are you connected to Visa? And she's like, oh, well, we work for this company that does collections for Visa and all this other stuff. And I said, okay, all right, I think you're trying to trick me, and I don't really appreciate it. I just hung up the phone.
Right, which may have been a different scam.
But I mean, you can
But-
tell market or something not right.
Not,
because
something was
when you
strange.
picked up the phone, they weren't there.
You got that old delay where you're talking to nothing for a minute and then they click in. Yeah, you know, it could have been real, I suppose, or it could have been a scam. Bankruptcy is a way of discharging contracts. In other words, when you go through bankruptcy, if you owe a creditor money pursuant to a contract, the bankruptcy says that contract is no more. That's really not working for my recording. Impossibility could be another way. For example, all the folks in New Orleans who may have had contracts that they now can't perform because the subject matter was destroyed, or they're just not able to do it anymore, or the price of whatever it is they were going to use has gone through the roof, which is different. Impossibility is different from difficult, right? If I contract to have my house built and my builder says, well, it's going to cost a little more than I said it was going to cost, then that doesn't mean that it's impossible to perform. It just means that it's going to be more costly. All right, damages. Compensatory damages. The actual amount of damages. So the next slide says consequential damages. Anybody remember the Ford Pinto? Anybody have one? Yeah. So what was the Ford Pinto known for? Blowing up, right? So let's say someone gets in an accident, someone rear ends a Ford Pinto, it blows up. What are the actual damages? Right, the car that you no longer have.
Hospital bills.
Right, the bills that you have to pay, or life you don't have, which raises a very interesting question, consequential damages. Not the, what is your body worth, right, but what is the absence of you worth? And so there are some consequences that go beyond actual damages, but they're foreseeable. Ford should have known, if they make an exploding car, that it's going to be, they may end up paying more than what it costs to replace the car. So lost wages, lost consortium. If anybody doesn't know what that means when your mate no longer can be your mate. And loss of a job. Did I say that one already? Those kind of things could be consequential as a result of it. It's hard for your mate to be your mate when you're dead. All right, punitive damages, punishment. So in Ford's case, they determined that Ford actually knew about the problem but didn't fix it because it was cheaper initially not to. Because what it would take to retool and recall cars, let's just let a few people die and see if they raise a stink about it. So when they found that out, the court said actual damages, consequential damages, and on top of that, millions of dollars in punitive damages because you are evil. Ford is evil. Well, actually, during the litigation and discovery, it came out that some memorandums about that the engineering issue was just some kind of valve that could have been fixed for a few dollars. I mean, the piece that would have actually fixed the problem wasn't that expensive. So, but they decided, we'll just see if it becomes a problem. So that actually came out during trial. Nominal damages, that's like $1. Well, technically you're correct. The other party did breach the contract, but there's no actual damages, which is not what you want to do, right? Let's say you go all the way through litigation, expend all that money that we talked about when you hire attorneys, and you have to go all the way through a trial, and then the judge says you get $1. That wouldn't be very good. All right, mitigation and liquidation. Mitigation, it says the injured party has a legal duty to mitigate. So notice it doesn't say the breaching party, it says the injured party. The non-breaching party has a duty. So if someone throws a rock through your storefront window, what do? Yeah, my last class said throw one back, but that's not the answer I was looking for. What would you do if someone throws a rock through your window? Call the police, then what? Get it fixed, right? I mean, not leave a big hole, so it leads to additional damage or theft. So perhaps it's rent. Someone doesn't pay their rent and vacates the premises. You may have an obligation to mitigate those damages instead of leave it sit empty. Liquidated damages. This is damages. This is the only kind of damages that you actually agree to before the breach. So the kind of damages we've been talking about are afterwards, but this is like the cell phone contract where you say, if you breach the contract, we're going to agree up front what you have to pay. That's fairly common. We've talked about the equitable remedies before. There's some of the equitable remedies that you get in a contract action: rescission, restitution, specific performance, making the other party do what they contracted for. Reformation. This is a little different. Instead of rescinding, undoing the contract, we're going to rewrite the contract the way it should have been in the first place. Quasi-contract we talked about before too, where there wasn't a contract but the court creates one. And finally, election of remedies. We can't always get every remedy at the same time. Let's say we're going to buy a house and the other party doesn't want to sell it to us anymore. And so we're damaged. Can we ask for specific performance, a sale of the home to us, and the amount of damages for not getting the home? Think about it. Let's try a car. Contract to buy a car, and you ask for the car and the money that you spent for the car. Why not? What would that be if you got the car and the money? It wouldn't be equitable. It would be double recovery, right? So sometimes the court's forced to pick a remedy because they couldn't make you more than whole. All right, let's stop there. And next time is practical exercise number 1 over this chapter, chapter 9.